You're watching the Legal Breakdown. Glenn, we've got some breaking news here about a massive money judgment that Donald Trump is now being forced to pay. Can you explain what just happened in court?
Yeah, Brian, it looks like a clean sweep. E. Jean Carroll has now beaten Donald Trump not only twice in the trial court, but twice in the courts of appeal. Our viewers will no doubt recall that E. Jean Carroll sued Donald Trump for sexual battery and defamation repeatedly because Donald Trump wouldn't stop defaming E. Jean Carroll. Well, she won the first trial to the tune of $5 million being awarded to her by the jury. That one withstood appeal, so Donald Trump already owed her $5 million going into today's ruling. Then E. Jean Carroll beat him in the trial court to the tune of $83 million. And today, the Court of Appeals affirmed the trial court's ruling and the money judgment to the tune of, get this, now $89.7 million with the interest Donald Trump has accrued during the course of the appeal. So basically, Brian, the appeals court today said that the second defamation trial was handled properly, so there were no legal issues or mistakes made undermining the verdict or the money judgment. With respect to the money judgment, the three-judge panel said that the amount awarded to E. Jean Carroll, courtesy of Donald Trump's conduct, was, quote, fair and reasonable. And then perhaps most importantly, the appeals court panel said that the statements Donald Trump made that defamed E. Jean Carroll, made during his first presidential administration, did not enjoy presidential immunity. That was the immunity the Supreme Court bestowed upon Donald Trump, contrary to the express terms of the Constitution. They bestowed it on him for criminal prosecutions. However, the court ruled properly that it does not bar civil suits from being brought against a president or a former president. So, this was a clean sweep. Donald Trump is now approaching $100 million that he owes E. Jean Carroll. And, I only wish that any of the members of Congress, the Republican members of Congress, would have just 1/100th of the courage and determination that E. Jean Carroll has.
So you know my next question here, and that's going to be, given that Donald Trump has already appealed this from the trial court into an appeals court, what's the next step for an appeal? Is this I'm assuming is in federal court and not the state court, and the likelihood then that the highest court would be able to pick this up?
Brian, predicting what the United States Supreme Court will do is a fool's errand. So let me be foolish for a minute and say there really is no significant constitutional question here for the Supreme Court to take up. Now, does that mean that they'll do the right thing and decline to accept this case on appeal? Donald Trump will almost certainly try to push this thing up to his Supreme Court, at least his 6 radical right-wing Supreme Court justices, who seem to forever be willing to expand Donald Trump's power and do a solid for Donald Trump. There really is no reason for them to accept review of a case that involves litigation between two private individuals, even if one was president at the time, because really the only lingering question is this presidential immunity. And the Supreme Court could not have been clearer when they bestowed immunity on presidents for their core constitutional functions, even if they are committing crimes. That was exclusively a ruling that had to do with the criminal prosecution of the president. Okay, so now let me play devil's advocate to my own reasonable argument. Will the Supreme Court want to expand protection for Donald Trump even further and say, you know what, upon reflection, now that we are taking up the issue of whether a president should also be completely shielded from defaming and sexually abusing someone, maybe we're going to go ahead and expand immunity to civil lawsuits as well. I mean, is there anybody who can say with confidence that there's no way in hell those 6 justices will do that for Donald Trump? I'm not willing to say that.
Just a quick note for everybody who's watching right now. If you'd like to stay on top of this legal news and support our work, which is completely free, the best way to do that is to subscribe to our channels. I'll put the links to both of those channels in the post description of this video. Is there any tortured rationale that you could come up with that might offer some type of a basis for the Supreme Court to actually take this up?
None. And here's why, because this is actually an issue that has been litigated many times over. Can you sue civilly a government official, including a president, for conduct that that person undertakes while in office? And the settled principle of law is that if you are acting within the scope of your official duties as president, like you're signing legislation or you're entering treaties with foreign nations with the consent of Congress, those are the kinds of acts that are within the official duties of a president. Let me use a quick analogy. Let's assume that you work for the IRS and you're conducting audits of taxpayers, and you find that some taxpayer has, taken deductions that the law doesn't allow. So what do? As the IRS auditor, you notify them that this was not a proper deduction and they have to pay some additional tax. Can you imagine, Brian, if that taxpayer, that aggrieved taxpayer, could then sue the IRS auditor? Every governmental decision that somebody didn't like would then tie up government officials and employees in litigation, trying to defend why they were acting within the scope of their official duties as they were. So that's why I think it's a sound principle, this sort of limited governmental immunity, this sort of limited immunity for government employees and officials and even a president when you're just doing what you were elected or hired to do. But here's the thing. No president is elected to defame somebody that he had sexually battered,
Right.
From the pulpit of the Oval Office. That's not within the official duties of a president, and that's what courts have already ruled. So, will the Supreme Court, again, want to revisit that and carve out some special exception for a president and say, we do think a president is elected to defame his victims? That, to me, doesn't make a whole hell of a lot of sense.
Glenn, did anything stick out at you from the actual ruling itself? Because obviously this is a pretty novel case here that we're dealing with, where a sitting president is appealing a defamation case against a victim who he was accused of sexually abusing. And so did anything stick out at you from the judges' mouths themselves?
Yeah, it's a great question, Brian. Together with ruling that this amount, which is pretty dramatic, right? It was an $83 million judgment, which has now climbed a little bit, courtesy of interest. They said that was fair and reasonable, given what Donald Trump did. Not only did they say he doesn't have presidential immunity for civil suits, and not only did they say there were no legal issues or errors warranting reversing the verdict or the jury's money award. Here's something they said. It seems like they wanted to make sure they emphasized what Donald Trump did and why it was so egregious. So here is a quote from the new circuit court opinion. Quote, Trump's attacks against Carroll were not isolated. Rather, they continued throughout the pendency of the nearly 5-year litigation and became more extreme and frequent as the trial approached. And Brian, the panel even noted that his continued attacks on E. Jean Carroll came even after he was found liable for sexual abuse and defamation, and even during the second trial itself. It seems they wanted to put an exclamation point on their conclusion that it may sound like a lot, $83 million, but it is a fair and reasonable amount given Donald Trump's conduct.
What about an instance where Trump just opts not to pay? Like, how do you enforce a money judgment on anybody, much less the sitting president of the United States, who's been shown to be pretty hostile to any rulings that he doesn't like?
Brian, the courts are well equipped to enforce money judgments. Once a case is over, once a decision becomes final, you can garnish somebody's wages. Wouldn't it be a heck of a thing if E. Jean Carroll had to garnish the wages, the pay that a president of the United States receives, but that is an available option. She can go after his real property. She can go after his liquid assets. There are lots of mechanisms for a plaintiff who has won a money judgment to make sure that the person can't just avoid paying out on that money judgment. So that is something that I think E. Jean Carroll's legal team will have well in hand.
And do you anticipate, finally, we'll finish off with this, do you anticipate any situation where Donald Trump decides not to use this judgment as the deterrent that it was intended to be, but instead decides to defame her again, which would undoubtedly cost him, some multiple of what he's being forced to pay right now?
Brian, the smart money is always on Donald Trump not learning his lesson.
Right.
So I don't know if he has yet posted something on his social media platform about, this being a hoax, et cetera, et cetera. But I would keep an eye out for that. And then, I think it's just up to E. Jean Carroll whether she wants to successfully sue Donald Trump a third time.
All right, well, we will, of course, stay on top of that. If we have any updates here with regard to this lawsuit or further defamation at the hands of Donald Trump against E. Jean Carroll or any of his numerous victims, we will, of course, bring them to you. For those who are watching, if you'd like to support our work, please make sure to subscribe. The links to both of our channels are right here on this screen. Best way to support us, best way to support independent media, and it is completely free. I'm Brian Teller Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.